All right, we are live on YouTube. Hi, everybody.
Hello.
Hello. Hello, I'm unmuting Miss Baressa. There we
Hello.
go. Okay. I'll hand it over to Lene to start.
Hello, thank you. So welcome everybody. Thanks for joining us on our first CCBA virtual meeting. We're very, very fortunate and grateful to Judge Edgeworth and Judge Thompson, Judge Barissa, and Judge Novak to join us today. They're going to talk about all they want to do is Zoom, what to do kind of conducting court during the COVID-19 pandemic. But just a couple quick announcements. The CCBA board has been meeting and I'm so sorry, y'all. My printer has decided to start acting up. We are meeting and we are trying to put together some sort of COVID-19 task force to put some plans into place, not just about what's going on in the pandemic right now, but kind of what we can do to help our community after we all have the shelter in place orders lifted and we start going back to normal life, because we anticipate there will be some needs in our community, and so we want to help with that. The other thing is that there's discussions around the holiday party and doing something different this year that will set up us to help our colleagues and our friends in the bar as well. So if you're interested in being involved with the task force, or if you're interested in being involved with kind of the direction of the holiday party this year, which will be different, please email me at lene@calvaryspunner.com and we can get you connected with everyone who's involved with that. And on that note, I'm going to go ahead and hand it over to Judge Edgeworth, and just know that next week we are going to have a part 2 to today's presentation on April 24th, same time, same place. Judge Edgeworth.
Okay, thank you so much, Lene, and we are happy to do this today. I have with me Judge Thompson, Judge Baressa, and Judge Novak, and what we're trying to do is... Hi, Bar. Well, hello, everyone. We're trying to mix it up a little bit so that you hear from different judges at different times on kind of how they're doing things. And to answer questions as we go along, there is a chat function on YouTube, so if you have questions, feel free to type those in. I wanted to start out, I'm just going to start giving a brief overview of some helpful information that is coming from the top down. And what I mean by that is, if you have not already taken note of these websites from the Texas Judicial Branch, the Office of Court Administration, and specifically txcourts.gov, you should. And the reason why is because that is the group, they basically run the judicial branch. And they were on top of all of this immediately when the stay-at-home orders started happening. David Slayton is the administrative director, and he has been incredible to make sure that there's information being given to all of the judges throughout Texas that is coming from the Texas Supreme Court. So what you've seen, at least from Collin County, what we've tried to do is through our Facebook District Courts page, when we're getting the orders, trying to share it there and have judges share it individually. And what I've heard from some attorneys is there's so many of them, where do we go to find them? And what you do is go to the Texas Judicial Branch Court website. Make this a bookmark on your computer, because it has everything. Look, it has the emergency orders, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So you have the actual information on the order and the date. Then if you go back to home, this is fantastic. It has information on Zoom. If you're trying to get more information on how to run a Zoom hearing, there is a ton of information here on how to do it. What is so incredible and fantastic about our Texas Supreme Court is that they were on top of this immediately and obtained licenses for all of the judges in Texas to use Zoom to conduct court remotely. And that is what has really helped every judge in Texas do that. And so because of that, they also were right on top of testing it out. I'm sure if you haven't, you should have seen some presentations by Judge Miskell, who also has been really involved in this and was trying to make sure that we as Collin County also had the information and were able to do the hearings. If you're not really sure what some of these orders mean, there's even a page on court operation guidance. And this is giving some additional information straight from the top again on if you've got different questions about remote hearings and what some of these emergency orders mean. It's all right here. And another fun thing, if you're just bored in the middle of the day, the Texas Judicial Branch has put together a page of all of the YouTube channels that are currently going for all the different courts in Texas. I do not believe there is a logical order to the list, so you've got to specifically look for them. But it even tells you, for example, right now, these courts are having hearings if they're live streaming, and then all of the courts, and then when it says watch, what that's going to do is take you to that court's YouTube channel. And the reason that the Office of Court Administration did this was because they were trying to figure out how do we make sure we still have open courts. I'll talk a little bit more later about the debate that's going back and forth on whether YouTube is the best way to do it. There were two options in Zoom. One was Facebook and one was the YouTube channel. And YouTube channels seem to be the best option. I personally have, I've seen a few courts that are doing it by Facebook Live, and to me, it's just strange because you look on your Facebook page and then all of a sudden see a court proceeding, but that is another option that some courts have been doing. So I really wanted to make sure that you had that information at your fingertips because it's a great resource and lots of answers to many questions that people are having. The other resource I want to make sure that you're taking advantage of or being aware of is the district courts, Collin County District Courts website. And I've had some attorneys ask, hey, we have all these different courts and people have different procedures and where do I find them? So if you go to the specific court page, for example, this is mine. I created some rules for Zoom hearings. The other courts have as well. So, and most of these are pretty similar, mainly because we are all looking at some of the same procedures. For example, here's Judge Thompson's rules for remote proceedings. And it's just to give you some guidance to try to help you make sure that when you're setting this up, that hopefully it's answering questions before you have them. So mainly I just wanted to start out with, this is why we're having so many remote hearings by Zoom. This is where it all came from, and give you some resources to look for if you're trying to do your hearings. Next, I wanted to go into some more specifics and give an opportunity to some of the other judges that we have here to talk to you about, okay, we've heard a lot about what the essential hearings are, whether it's protective orders or temporary restraining orders. What about non-essential hearings? And I know your clients probably believe that all of their hearings are essential, but how are the courts handling it with things like a family law bench trial or in civil cases? So I thought we could start out with Judge Baressa, since she's on her civil island of civil procedure and has been working very hard to create some of her own orders, which has been incredible, and to try to give some guidance if you have civil cases in her court, how she's handling it. So take it away, Judge Baressa. Oh wait, we have a question or a comment. Yes.
Yeah, I just wanted to comment, we've got 64 people watching and no questions. So for those of you that are watching, if you look to the right-hand side of the YouTube screen, you'll see where it says top chat. And I have a message on there that I typed in so y'all can see that we're taking questions. So if you go to that portion, if you go down to the bottom, it'll let you put some questions in, and feel free to put them. We'll keep track of them, try to write them down, and we're going to answer as many as we can as we go through this. Okay, so now take it away, Judge Baressa.
Thanks. Hi, everybody. So as Judge Edgeworth mentioned, I am a little bit on an island, being the county's only civil court. What that basically means is that most of the matters that the Supreme Court and the other district courts are deeming essential are very rarely going to land in my court. So it would make zero sense for me to have an essential only policy, because it would basically mean my court would come to a screeching halt. So we are absolutely trying to move forward with as many non-essential matters as we can. In fact, rather than canceling our existing settings, we did everything that we possibly could do to keep every existing setting. I've taken a lot of things on submission where evidence isn't required. And we are mostly just trying to not get behind because of the quarantine. So if you have civil cases in Collin County, there's probably about a 45 to 50% chance that it's in my court. And so don't think that you can't get a non-essential hearing. You can. The Zoom hearings are a little bit harder to come by than submission hearing dates, only because I can't have as many Zoom hearings in a day as I can have hearings at the courthouse. Things move a lot faster when everyone's in the courthouse. So the hearing dates are a little bit fewer and further between than they would be if we were back to normal, but you definitely can get hearing dates for non-essential matters. And if you want it taken on submission, from day one, I've had a daily submission docket, because a lot of times attorneys have discovery disputes or things that don't necessarily require argument. They just require my attention to look at the issue and make a judgment call. So if you have those things, don't be shy about setting them. But I'm going to hand it over now to some of our general jurisdiction court judges to talk about how that's probably very, very, very different from what they have in their courts because of the variance in the number of essential matters that they see right now.
Judge Novak, do you want to take it?
Absolutely. Thanks for doing this, by the way. There's not that much that changes, I think, probably from court to court in terms of what we can and can't do. I think one of the biggest misconceptions or issues that comes up is that we can't do something. And I want everybody to know that that's not necessarily the case. There are certain things that we cannot force people to do, but if we can resolve your case, if we can move things along with everybody agreeing to go forward, then that's something that we can certainly help out with and do in any number of ways, whether it involves mostly on Zoom, submission, working through email, or where one or two of the parties or witnesses or something have to come up to court, then those things are still on the table for everybody in Collin County. It's just a question of figuring out what can we do, what's the best way and most efficient way to do that while keeping everybody safe, and making sure that these cases can move forward as best as they can. Now, if there's going to be an objection, if there's going to be a problem with it, then we have to look to the rules to see what we can allow or stop or not allow. But for the most part, I think all the courts are working under that principle, is that we can help. We just need your input and your help in making sure that everybody's on board with moving the case forward. And if we have that, then it can go on.
All right, Judge Thompson.
Yeah, pretty similar to all that. Basically, if we want to work, and if you do, we're here for you. There are certain things, obviously, that are more essential than others. And the rules do say that we can require people to hear remotely. So that's something that we've talked about in some of these other things, is if you have somebody on the other side, let's say you want to move forward, and what you're hearing from the other side is they don't want to do it by Zoom, they want to do it in person or something like that. We do have the ability to require them to appear remotely if they have proper notice, they're part of the case, that kind of thing. And if they don't, then they don't. And, you're probably going to get what you're asking for. So keep that in mind. If somebody is kind of stonewalling you and you've got an issue you really need to kind of move, we have the ability to help you with that. And we'll find a way to fit that in and make it work.
And I think a good point just to keep in mind as well is we're trying to make sure that we're giving you opportunities to still move your cases. So for example, family law bench trials. What I think most of the judges are doing across the board is we are setting those by Zoom, and leaving it to the lawyers. If you are objecting to having the jury trial, I'm sorry, not the jury trial, the bench trial remotely, then you would handle it like you would handle anything else. You're going to file a motion for continuance. You're going to give us your arguments. What is not persuasive is a general overall statement about that we are in quarantine and have a pandemic. We know that. And that's why the Supreme Court has issued so many orders that allow for where you don't have exactly the same requirements for rules of evidence and for people appearing remotely. What does help though is just be real specific. I mean, maybe it is as specific as I have 4 children under the age of 10, and there is no way I can have a jury. I keep saying jury. It's natural for me because I miss jury trials. Right. So going back to, if your argument is, I can't be in a room all day and conduct a bench trial because I have 4 children under the age of 10. I'm the only person taking care of them. Or maybe that's the situation for your client, or maybe you have a whole host of experts all across the country. I will say there are ways that we can help with that. I mean, we can schedule it. The nice thing about remote hearings is we can give you an exact time, and that's when the person is going to be appearing, and then they're off and you don't have travel costs, and that's very helpful too. But it's helpful if you're asking for a continuance to be really specific on why you need it and ask the court for a hearing on it. And we'll do it just like we would if we were looking at you in the courtroom. And there are a whole host of reasons why it may not be the best time to do a bench trial, or maybe it is. In talking with some of the other judges, especially with self-represented litigants, and yes, we are still having remote hearings, even if you don't have an attorney. Sometimes that's even easier for them. So we're willing to be flexible and try to keep your cases going. Anything else y'all want to add on that before we go to another topic? Okay. All right. Next question is, how should the lawyers handle all of their different settings and procedures? Because I'm sure, I know mine is, many of our court coordinators are pretty overwhelmed right now. There's a lot going on. What would you recommend they do if they're worried that they don't know, for example, if they are actually going forward or not? We can start with Judge Baressa. We'll just go back in our same order.
All right, I would say emails to the coordinator are always welcome. Yes, I know my coordinator's getting a lot of them right now, but even a second reminder isn't a terrible idea if you haven't gotten the same day answer, because that's the standard that we're trying to keep, is for everybody to get some kind of response without having to wait. So just, yes, don't be afraid to reach out with your question. There's no question that's stupid or unnecessary. If it's important to you for preparing your case, then it's important to us. We are trying to be consistent in our responses to everyone. That's why we've put together the remote hearing rules and some other orders to try to help guide cases along so that everyone's getting the same feedback and the same opportunities. But I would just say, don't be shy about sending your questions to the coordinator, even if it might take a second follow-up email. I don't think we're at that point yet, but hopefully you'll get your answer promptly, and we'll be able to keep moving these cases forward as fast as you guys want them to move. Maybe faster, I don't know.
Now, I'm looking now at some of the comments, and Judge Baressa, I'm wondering if you have any thoughts on this as well. I've had this come up. Subpoena power, because if we're trying to get witnesses to appear remotely, what we have been doing is telling lawyers, well, you do it like a regular subpoena, and you say you are to appear at this date and time over Zoom. And the questions have come up, well, what if they don't show up? I don't know if you've had this come up yet, or if any of the other judges have. I'm opening it up to everybody.
I haven't had an experience with anybody not show up. I know that contempt and some other things procedurally are a little more difficult to do right now since we're not having in-person appearances at the courthouse. I'll defer to Judge Thompson or Judge Novak if maybe they've had a different experience.
haven't had, it hasn't been an issue for me yet. There's a lot of questions that looks like on the chat about how to compel people that aren't part of the proceeding. And I've watched a lot of these across the state. There's not a good answer yet. So unfortunately, that's one of the few areas where we struggle. So experts maybe that don't want to come, other third-party witnesses that don't want to come and don't be involved. It's really unclear whether we have any power. You know, we can subpoena them, but if they don't show up, the ability to hold people in contempt. I mean, one of the issues we're having right now is trying to limit the people going into the jail that are higher level felonies, violence, you know, those kinds of things. So we're probably don't have the ability right now to hold somebody in contempt like that. So unfortunately, we do not have a good answer on that. And I haven't heard one yet. If somebody else has, I think we're looking for one. It may just take somebody trying something and letting them run it up the flagpole and see what the people that grade our papers will tell us about that. But for now, I haven't heard of an answer on that from anyone, unfortunately.
So I think this is one of the concerns that people have brought up a few times, but I don't know of actually having an issue with anybody that I've actually heard that this occurred for. And maybe I'm wrong with it, but it hasn't happened to any of the judges here yet. And so I would tell people to do the same things that we would do normally. If we're subpoenaing somebody to appear in court and they don't appear in court, you know, what are the remedies at that point in time? Is it really ever a situation where we're going to go and arrest that individual and hold them in jail until they come and testify? That's not likely something that's going to happen. What you're going to have to do is work with the court, where maybe the court has to pick up the phone, call these individuals, get them on the phone, explain to them the situation, explain to them what could possibly happen in the future if they don't. All of those things that we kind of use maybe secondarily in terms of helping either side, either party get cooperation from other individuals. And so I think you just got to use your common sense to get to that point where, again, we're happy to help. Everybody here is willing to do what is necessary. And if you're having a situation where a witness or somebody is not cooperating, then, you know, let us deal with that. Let us pick up the phone, call them, see what we can do, and then we'll kind of cross that bridge once we get to it and do what we can and exhaust all the, you know, possible remedies. But, you know, it wouldn't really be that much different if they weren't responding to a subpoena and just not showing up to court. So I think you follow the same rules and just you know, try to work with those problems as they come up.
More specifically from a procedural standpoint, if you're wondering what does your subpoena look like? What we have done, I'm going to go back to this website. So for example, under the 219th, and I'm going to give a shout out to Judge McCraw, because she was the one that initially drafted this. The notice of remote hearing, it looks like this. What you need to do is actually get the meeting ID and the link from the court coordinator. And then you would put that, this is what I would recommend. You would put that in a subpoena. And so it's just like what a subpoena looks like, but instead it says you are to appear by Zoom on this particular day. Then if the person does not show up on that particular day, I think you handle it like you would if you were in open court. And it may be something as dramatic as you need to now ask for a continuance and make sure you don't close your evidence because this was an important witness. You're going to have to take that into consideration as you go along. Do you think that a court is probably not going to be as lenient on someone if they don't appear by Zoom? I think so, because this is even easier, especially if they're an out-of-state witness. They should be able to pop on and be part of the hearing. But as Judge Thompson mentioned, this is something that I don't have a good answer for. None of us do yet, and I haven't seen guidance yet come out from the Supreme Court specifically on that question. All right, there was another question about how to submit exhibits for Zoom hearings. I've seen it two ways that the judges are doing. And again, it's just a question for the coordinator. The easiest way probably is to be emailing the exhibits to the court coordinator. In my procedures, and I believe in Judge Thompson's as well, we're asking for you to do that at least a day before the hearing. One of the questions has come up, well, I don't want the other side to see my exhibit first, because what if I want to impeach that witness? That's up to you on what you want to show the other side as far as you being able to use it at the hearing. What we are asking for is that you send the exhibits to us first so that our court reporter has it, and so that I can also pull it up on my screen and see what it says. That's the first thing. Then I would say for any Zoom hearing, the more exhibits you can agree on before you start the hearing, it's going to make it go so much smoother. So highly recommend trying to agree on exhibits before you start. And then 3, if there are exhibits that you know you're not going to agree on, or maybe you have an exhibit that you expect you may have to use for impeachment, but you don't know yet, just like at trial, you would hold on to it. And then if you've got to submit it the day of the hearing, you do that, whether that's emailing it to all the parties while you're on Zoom. You can share your screen if you're trying to show an exhibit to a witness so that they can see what you're talking about. And as far as making sure you're comfortable with that, practice. I know all of us together have had practices. I practiced with my staff, just practice using the technology before you start, and it'll make it hopefully a lot easier. I did see that there was a question about criminal matters.
Before we switch off of that topic, I was just going to add a note that when it comes to exhibits, you definitely want to contact your court ahead of time, because we do all have different processes in place with our staff, depending on their capacities to handle certain things. And so for my court, for instance, I have a special email address that's 471 exhibits at co.colin.tx.us. And that's the sole depository for exhibits for hearings in my court right now. And that's so that my court reporter and I both can receive them and view them. And we are asking that everybody try to pre-admit as many as possible. So if you can send some that you know that are not objected to, that speeds things along. But I also, I don't have the requirement that you have to submit it in advance, because I have gotten feedback from attorneys that they want to be able to use exhibits if they need to impeach someone, or if somebody testifies in a way that was unexpected and now they need to use the document to get more answers. I don't have any prohibition on using additional exhibits during the hearing, but my procedures would just have you, again, email it to that particular email address as you're introducing it. And it slows things down a little than if we were in the courtroom, but it still allows us to proceed as closely, I think, to how the evidence would be presented if we were in court. So again, just check with your specific court before an evidentiary hearing to find out how that judge wants to receive the exhibits and when they want to have those exhibits. I think Judge Thompson had something to add.
I was going to follow up. I think one of the questions we had related to exhibits was, can we give an example of the relaxed rules related to exhibits? And something like that might be certified copies. So if it looks like it's what it purports to be, I don't think any of us are going to reject something because it doesn't have the certified seal on it. So that's an example of that. There was a question earlier about unsworn declarations on waivers, and people having a hard time finding notaries. That's another thing that's been changed. The governor issued an order that said you can get things notarized remotely. So now you're allowed to get things notarized over video. And then I haven't had a chance to look up the rule, but they changed the rules a couple of years ago to allow people to basically use an unsworn declaration for almost anything. So this is a scenario where I think most of us are likely to take one of those. We already have a rule that kind of lightened up a lot on that. You combine that with the governor saying you can do things remotely, and the rules that we can kind of relax some of the evidentiary rules on this. And I think to the extent you have something where you need an affidavit, some kind of unsworn declaration is going to be sufficient for most of us on that.
And on a related note, since we have been empowered by the Supreme Court to accept written testimony in lieu of live testimony, it's a lot easier, I think, for prove-ups and things that are largely uncontested for you to do those on submission with written testimony rather than having to get everyone on coordinating a Zoom hearing for something that's not a contested matter. So we're also doing prove ups on submission using that particular rule that allows us to take written declarations in lieu of live testimony. So that's another tool that can help keep cases moving.
So I think from the standpoint of evidentiary issues, we just always have to kind of relate back to the issue of whether or not the document purports to be what it is. And if there's indications that it is, that doesn't make it necessarily something that you can't introduce as evidence. It's going to be accepted just in any situation, regardless of whether or not we're actually in court or not. You're going to have to go through those steps. And if you don't have one of those little bits, whether it's the seal or something along those lines, I think, given where we are with how these cases are proceeding, is going to, be in kind of looking at the court's perspective, you're going to be able to admit most of those things anyway, because you're still going to have the opportunity to cross-examine people on it. You're still going to have the opportunity to bring in your own evidence to counteract some of those things. And I would tell everybody to look at the unsworn declaration portion, where, basically if somebody attests that it is a true and accurate statement and they're submitting it under the threat of perjury, it gets in. Well, how's that really any different than a notary? So those kinds of things are going to pop in, and you just have to use, various means to get that document in, and a lot of things have come in. And then one thing that I've done also in the situation where we didn't have something that was notarized, we did have something that was signed and, was an unsworn declaration. One of the parties objected to it. Well, we had all the people there in the hearing. So I just asked them under oath whether or not it was a true and accurate copy. There it is. And so it becomes admitted at that point in time. And we've kind of solved any of those issues, and you can use it at that point in time to cross-examine them or use it in later hearings because the person swore to the veracity of what's in it. So again, just a little bit different tricks and ways to look at things without going, throwing the baby out with the bathwater.
All right. Judge Thompson, I think you had some Zoom tips that you wanted to give.
I do. These are more things we have experienced that we would like to share with those of you maybe that have done a lot of these. So one of them is to dress appropriately. So you can see we're all in various stages of semi-casual. Judge Edgeworth looks much fancier than the rest of us, but I think most of us have our robe. We're using our robes when we do actual hearings with people because we're still trying to convey to them a sense of the formality of it being a court proceeding, even if it doesn't look or feel like one. There was a funny story out of Broward County in Florida recently about an attorney appearing without his shirt on, and another one appearing in the bed under the covers. So we know and love most of you in our Collin County Bar, but we don't want to see you in your bed or with your top off. So appropriate attire is requested. So luckily, I don't think we've had much of that happen yet. It's okay if kids and dogs and all the, yard guy intervenes. We're used to that. So don't panic about it. We have a rule with my court. If we hear a dog, we have to see it. So if your dog is going to bark, be prepared to get them on screen so everybody can enjoy how cute your dog is. And then we'll just go back to what we were doing. But don't panic about stuff like that. It happens. Be careful on backgrounds that you use. So you can see we're all using a background. It does funny stuff. So if you move out of the picture, part of your head disappears. Things, if you try to hold something up, it's weird. So be careful with that. Also be careful with the backgrounds that you pick. So the background, if I'm doing something maybe a little more informal, I'm going to go to my happy place, which is in College Station. But this background isn't necessarily appropriate for be conducting a work hearing. So be careful about that and make sure what you have on your background is something that's appropriate for other people to see if you're going to have one. Make sure you turn off, there you go. Make sure you turn off all of your notifications and things like that so you don't get a lot of pings and things. And hi, all you got cats and kittens. Is that what we say on that one?
Novak, what are you doing?
Yeah. So
use that one.
Judge Novak is giving us an example of inappropriate attire and background all in the same picture. Please do not dress like this awesome guy. So one thing I'll tell you too that's an issue for the court reporters is trying to hear everybody. You can't talk over yourself. So you'll see the green box on Zoom goes to the person that's talking. But when other people start to talk, it just sort of jams up and nobody hears anything. So one suggestion I have is if I'm going to turn off my background because you can't see if I hold up a piece of paper. So here's an example of something you might consider. If you have an objection, have an objection and make it obvious to everybody. So what'll happen is when people talk over each other, the court reporter's not getting down what the witness is saying. They're not getting down your objection or anything else. I would not at all be offended if somebody kind of held up a sign in some way, did something to get everybody's attention, and then we will all stop talking and the court will say to you, okay, you have an objection, what is it? We can address it. So that's kind of a handy thing to make sure you're not, you're able to preserve your record when it's a difficult thing to do sometimes. And then one final thing is to change your name. So you'll see on the bottom left-hand corner, I have on here Judge Andrea Thompson. I could make that supreme leader of the free world if I want to. I can call myself whatever I want to call myself. So the problem though is when we have a hearing, particularly if we have a lot of people on it, this shows up as iPhone 4, Susie T's, phone, but Susie T is not one of the participants in our, because you're on your wife's, iPad or whatever it is. You have the ability to change your name. At the beginning, you can go in and there's blue buttons in the top right-hand corner. And if you click on those for yourself, there's a drop-down menu and it tells you to rename. So it's super helpful for us and frankly, everybody else that's going to be in the hearing. If you will rename yourself to something that everybody then can identify the case you're with, maybe, I saw a tip recently that said, put your name and the party you represent even. So you can change it for every case and say, Andrea Thompson representing City of Plano or whatever it is, that name can be relatively long. So give yourself an identifier that people will find helpful during the hearing and not the nickname that your kids call you when they're mad at you. So, all right.
Any other tips on Zoom hearings, Judge Novak or Judge Baressa, that you have? I would, before I over, I definitely agree with Judge Thompson. I've done a presentation before on Love Your Court Reporter and how to make sure everything gets in the record. It is even that much more important right now because our dear court reporters are desperately trying to make sure that they can hear what you're saying in between the glitches, in between talking over each other and the dogs barking. So you need to be even more aware when you're talking to make sure that, for example, if you have a case site, please tell me the entire case site. I had that come up this morning. If you are going to be objecting, like Judge Thompson mentioned, you've got to get everybody's attention that the objection is happening without being over the top about it. And all of those little tips can help to make sure that you have a good record. And so far, the feedback I'm getting from the court reporters is that they can hear you. It is working. Also the court reporter's transcript still is the official record of the hearing, even though you are doing it remotely. So if you need a transcript, they can still do one. That's still available. Okay, other tips that y'all. Yes.
Sure. Just to build on what you were saying, Judge Edgeworth, I would also say that it's helpful to the court reporter if you have a party name or a company name that's unusual or very lengthy, if you would spell it the first time you say it, because the court reporter will then be able to refer back to that every time that word keeps getting repeated throughout the proceeding. I know it's common for attorneys to write those things down and hand them to the court reporter at the beginning of a proceeding, and now we don't have that option. So when you're introducing yourself or introducing your client, if you could spell out their name or spell out the witness's name, that would also be helpful in getting a clean record and making sure the court reporter knows who you're referring to.
Okay, Judge Novak, anything else?
No, I think we've covered, most of the issues, and I think most of the people that we've, we're dealing with here have handled those. And if it's your first time, then obviously look into calling the court or emailing the court and asking for, advice on how to handle those issues coming up. But I think my first Zoom hearing was a situation, it was kind of already mentioned. I had one of the parties appearing, waking up right out of bed, 9 a.m. There they are in bed, and they're right next to each other. And one's got a phone, the other one's got a laptop. We're starting to get feedback. And I don't necessarily know what's under the covers, but it was my first Zoom hearing. So it was a little bit awkward. I'm trying to talk and have that conversation with the attorneys while their client is there, just having woken up, not brushed their teeth yet. So it was a little bit of a challenge. I think we're probably better prepared for it now than we were previously. And we'd probably handle it a lot differently than I did that first time. But those things occur. So just, keep in mind to slow down so that we can kind of process through some of these things. And we're just gonna have to work through, objections, impeaching witnesses, all those things that are, we're able to do a lot more smoothly when walking towards the witness stand. We can't really do anymore. And so we have to just go a little bit slower. And I think to some of the questions, it does slow things down. So, we're trying to stick to our time limits because we only have a certain amount of time to do the Zoom hearing. But I think you're seeing at least a little bit of relaxing of the rules when it comes to a lot of those issues, just so we can, make sure we get everything right and do things correctly. So there's no hard and fast rules. And I think all of the judges agree with that. And it can change by case by case.
And of course, there are always going to be things that are outside your control. I've started not doing Zoom hearings until 10, because before that, I promise you, one of my neighbors is mowing their yard or trimming their trees. It's every day. I mean, it just is. And so there are always going to be things that are kind of outside the scope of your control. But I promise you, the judges are all coping with the exact same things. And you are not being judged for the kids that are running in, or the guy that's working on his diesel truck in the driveway right outside your office. I mean, those are things we're all coping with. So, it might be my husband working on the diesel truck. So sorry if you're trying to do a Zoom hearing, we might be responsible for some of those interferences. But anyway, just know that we all can relate and we all understand. And so if those things happen that are outside your control, we're all just going to, have a good laugh about it and keep going.
I just noticed Judge Novak has given you a demonstration of how you can change your name, Carol Baskin's second husband. By the way, if you aren't really sure what he's referencing, highly recommend Tiger King on Netflix. It is fascinating to watch, and then you'll know where all of these references are coming from. A few more things I wanted to talk about, kind of the ethical implications.
Oh, wait, I should take my bar picture down while we're talking about ethics. Hold on.
Yes, perhaps you should. That would be good.
Well, I mean, if you want to have a conversation about ethics, I think Tiger King is probably about the place to start with a lot of issues that we may face as attorneys ethically.
It is, but the moral compass perhaps is different for us all. Okay. What I wanted to touch on is because we have been directed, encouraged by the Texas Supreme Court to be streaming our hearings on YouTube. What does that mean for you and your clients? So the first thing it means is that I saw Kimberly Munson, I think, commented that we have a do not record notation on the bottom. I can admonish, and other judges, that's what we've been told to do, admonish at the beginning of the hearing if you need to. You are not to record this hearing. Can I absolutely prevent somebody from recording it? Nope, sure can't. I can admonish away, but if they're doing it, I don't know who they are. That raises another issue, and it's really been a fascinating discussion back and forth among the judges of what really is open courts and what does that mean? Because if I'm conducting court normally, can someone in another state just pop in and see what's going on? No. What about if I have a very contentious and or family law case with a lot of issues that you probably don't want your neighbor to know about? If I'm conducting court and regularly you have the actual neighbor that's in the court and we all know who's watching, not necessarily true if it's on YouTube. Even though that is the reality, this is the way that we are trying to make sure that we're all still allowing for open courts, and there hasn't been a better option that has been presented. Because of that, what you as lawyers need to remember is if you are showing exhibits, for example, if you're showing them during the hearing and it's on YouTube, you've just shown it to the world. Is it likely perhaps that you have hackers or people that are very interested in somebody's bank account information watching the hearing? Maybe not. But for example, I had a hearing a couple of days ago where there were bank records that were shared to the screen and it had the full bank account number on it. Then you've got some other issues that involve trade secrets perhaps, or a lot of different things. We've been given additional direction from the Texas Supreme Court on ways that you can shut it down if it shouldn't be live on YouTube. And if you're worried about that, just bring it to the court's attention before we have the hearing. And there are ways that we can address that as well. Other ethical implications. All right, how do you invoke the rule? Well, on the Zoom hearing, the way that we're trying to handle that is asking before the hearing starts, who are your witnesses? And I've asked that the witness names be given to the coordinator so that I know if there are people in the waiting room, who am I looking for? That also goes back to Judge Thompson's comment. I'll make sure it has the correct name because Carol Baskin's second husband doesn't help me if that's a witness or if it's someone that's Zoom bombing. You may have heard of that too. There are some folks out there that like to pop in on Zoom hearings and show inappropriate materials. So if I know beforehand who is expected to be at the hearing, I can keep witnesses in the waiting room until it is their time to talk. Can I prevent them from watching the YouTube live? Sure can't. I can admonish them not to do it. Do I know if they're doing it? I don't. And this really goes back to attorneys and our oath and our creed that these are things you should be talking to with your witnesses. If you as a lawyer really are worried about an opposing counsel that you have on the other side, when you get that witness into the actual Zoom hearing, ask the question. You're under oath now. Have you had any conversations by chat or by text with opposing counsel before this hearing or while you were in the waiting room? That's how you would try to get around that and make sure that it's being addressed. The good news is, and definitely what I've seen is lawyers are really handling this well. They're doing a great job under difficult circumstances to try to move forward with these hearings. I've seen some comments also, just as an aside, about depositions and that they are soul crushing to try to do a deposition by remotely. I think for trial lawyers and trial judges, anything remote is soul crushing. And I understand that it's just not as much fun and it's a lot more difficult, but we're doing the best we can under the circumstances. Anything else that y'all want to add? Oh, one thing too that's happened a couple of times is sometimes we have really inappropriate things discussed on during our hearings, and a couple of judges have had their channel revoked because of inappropriate material. We're trying to make sure that we are addressing that as well, but sometimes that just happens. All right, anything else that y'all can think of on the YouTube issues or ethical issues that I haven't touched on?
So for purposes, go ahead. I'm sorry.
No, not at all.
About, hearings, you can jump over one another. Go ahead.
I don't know if this is tangentially related. If there's a hearing Zoom issue that we haven't talked about, maybe it's something we haven't encountered, maybe it's unique to your case, I would just say contact the court in advance. If you have that question, somebody else somewhere is going to have that question, or maybe had that question in a different court. And we are all communicating constantly about how to troubleshoot. And so that we can all be on the same page and we can all be addressing problems as they come up. So we don't, at least I don't think we are under any assumption that we have 100% figured this out and that we've anticipated every possible contingency. There are probably things that we haven't encountered yet. So if you have a situation that you don't think is addressed by our remote proceeding rules, or that you think is unique or needs to be handled a certain way, just ask ahead of time. And that way we have the opportunity to think about it and figure out the best way to do it. Because I think we are still all kind of evolving as the quarantine extends. And then I would say to also keep an eye on those websites that Judge Edgeworth mentioned at the beginning, because there may be additional orders and guidelines and helpful information that gets added as we troubleshoot more issues. One of them, for instance, being how to give public notice of certain hearings. That's something that is in the works right now. So just keep up to date on the court's orders, and if there's something you don't think we've addressed, make sure to ask the question.
So what I wanted to mention in regards to some of the evidentiary issues is kind of twofold. Number one, I'm sure the lawyers had to change their trial advocacy skills when we introduced videos and introduced different types of technologies into the courtroom over the years. And so we're kind of feeling that out right now as well. So everybody's going to do things a little bit differently as we go along. So is there a possibility that people are coaching? Is there a possibility that we're releasing information and those kinds of things are coming up, and we're trying to deal with them as best as we can. And so what we would ask, obviously, attorneys is to just try to, be patient with the rules as they're kind of developing. There was a question asked in regards to the video and what the feeds. It depends on the court. So the video feed is about 30 seconds, maybe about 15 to 30 seconds behind what's actually happening before it gets uploaded and before those individuals can watch it. So it's a little bit more difficult for people to interact with that along with the people who are on camera. And then what I would also point out is we're not in a vacuum. We can see people's reactions on the video. We can see what they're doing. You can obviously see when people are looking at their screen and scrolling as opposed to answering questions. Those are all things that play into our assessment of that person's credibility. Those are all things that play into our assessment of what they're saying. And so if we're getting that feeling, it's going to play into how they're doing it. And we may get that feeling that they're doing something they're not supposed to. We're going to step in and ask. And, those kinds of things shut those issues down. I have not seen any of those problems. I have not encountered those things. People, when they're being asked questions, are focused on the computer. They're focused on what's being said. And we're asking them to lean in, speak louder, do those kinds of things. So there's not really an ability to go and look at other things and try to figure out some way to cheat the system. So those things as they're playing out are just kind of working themselves out a little bit. But I anticipate you'll see some rules, at least in terms of trial advocacy and evidentiary rules coming up that will be adopted a little bit more universally as things play out.
All right. Anything else on that issue? Go ahead, Judge Thompson.
Well, I just say, it's not much different than what happens in person. So when I invoke the rule, I always give a little speech about you're going to go out in the hallway, don't talk to anybody. I specifically say, do not text anyone that's in here in the courtroom. I give a little speech about that. Well, guess what? As soon as they go out there, for all I know, they're texting everybody in there and they know everything. It's so different than on this. It's just up to you to try to figure out what you can. And like Judge Novak said, if you can tell that it seems really obvious, ask questions about it. Judge Edgeworth gave some examples of really good questions to ask about who talked to you and when and things like that. So do exactly what you would do if it was in the courtroom and you see somebody in the back is furiously texting and you're guessing they're texting the person in the hallway. It's not much different than this. One tip we heard in another presentation I saw was it looks like the witness is reading something in front of them. Ask them to move back further so you can distance yourself from your camera or move the camera. Please pick the camera up now and show the camera in front of you and things like that. So there were some tips from another presentation I saw about how to get the witness to show their surroundings and things like that to show they didn't have a stack of typed out, questions and answers in front of them and things like that. So I think that was it on that topic. We have a
Judge, I'll add this. So one of the things that we talked about is if we have children, most of our witnesses are doing this off their phone. So having them scan the room with the phone, if you're doing some kind of hearing that involves children, you don't want the parents involved. You want them in a private place in a separate room. You can take them there. You can tell them to take the phone and scan the room, show that there's not anybody there listening and that's not supposed to. that can work for other witnesses as well. Again, what we're dealing with in those situations, it may not be a laptop. Most of the attorneys are probably at their office or at home using a laptop. Most of the witnesses, most of the people we're dealing with, they're using phones. You can ask them to move that around, and those are ways that you can avoid some of these issues where there may be coaching, there may be things that they're not supposed to see, or people in the room that shouldn't be there. So try those different things depending on your case and what you're looking at.
I'm just going to add another tip. Obviously, especially in family law cases, there's the additional concern of what if it's a single parent? What if they have children that it's really hard for them to not be with the children if they're trying to have a hearing, and then you add on to that, well, now they just heard about all the litigation. A couple of options: earplugs. You can wear earphones while you're doing the hearing if it's not, especially if it's not evidentiary, if it's just something that with the attorneys are involved. And you can also do things by written submission, especially if it's pretty cut and dry issues where you're not having to call witnesses. Just keep that in mind as an option, that you can brief it and ask the court to look at the briefs and decide, so that you do have that opportunity as well. I did see some questions about, hey, do we think that we're going to continue to do some of the same procedures that we've developed now and into the future? I hope so. I hope that we can continue to use some of the, especially for remote hearings, if you have a witness that's far away, oh my gosh, how much money you can save if you're not having to bring a witness there personally. And we've already conducted phone hearings with witnesses like that, but it just makes it that much better when you can actually see them on the screen. And what's great about what's happened is that it forced the counties to look at the technology. And thankfully, the Texas Supreme Court had quickly discovered that Zoom was the easiest to use, because it was interesting. Right when all of this happened, our county was also going through some different options of, do we do Zoom? Do we do WebEx? Should it be court call? And a couple of us had tried with that other technology before we got the licenses to use Zoom. And I think far and away, it was discovered that yes, Zoom absolutely was the easier technology to use. And as we're all getting more comfortable with it, I think you're discovering that there are so many great ways that you can use it for hearings and hopefully save your client money too.
I agree. I think despite what I'm sure it's easy to believe, we do not want to make things harder on attorneys or their clients or their witnesses. Like Judge Edgeworth, we did a lot by phone. We used court call. There were times we would do that to do video if we had to. It was all pretty bad sound, pretty clunky. So we generally only did it where we didn't have much other choice, or something was really prohibitive for somebody involved in the case. We had to do it that way. The Zoom has been working out great. So I think most of us, from what I've heard, have the intention of trying to move forward with things. It's not ideal for a trial. It's very clunky to get exhibits and things in. You can do it. We are doing it now because we want to be able to help y'all move your cases if you have things that need to be addressed. A trial, a heavy evidentiary hearing, it's not ideal. Quick, easy stuff, motions to enter even, things like that. There's plenty of things that wouldn't require you guys to be coming down to the courthouse that could be handled this way now that we have an easier, more accessible option with better quality than what we had available to us before.
If you have not yet tried the interpreter function, perhaps you haven't needed to, and that's great, but it is really good. The interpreter function through Zoom, to me, it's definitely easier than court call, and it actually went well. You need to practice probably a couple of times before you use it, but just so that you know, if you do have clients that need an interpreter, Zoom has that function. We can help you get that set up. Judge Miskel's run a couple of practice sessions. I've helped out with or participated in one where we had the interpreters that we use often in the courthouse that were also practicing with it. So it works. It was actually very successful. So that's great. Any other comments, concerns? Let me see if I see anything else on YouTube. I like the pirouette rule.
Yeah.
Yeah. Okay. Well, final words. What we're trying to do is give you a part 2 next Friday with some other judges that weren't able to be participating today. So be thinking if you've got some more questions that you want to ask. Since things are changing daily, I just saw a long stream of texts about that the governor apparently was on live at noon, and we're going to be getting some new orders. So it is changing daily, and we are trying to be as flexible with it as well, and try to help you get through it too. Oh my gosh, Judge Novak.
Well, so the way I figure it is most people kind of refer to us as Muppets in some respects and how we handle things, but it may get that crazy from time to time, but thanks for everybody being patient and helping us out.
Yes. All right, this will stay up on YouTube. And if you didn't get a chance to watch it today, or if you wanted to go back and look up some of the websites, it'll be there for you. So thanks again and have a great afternoon. Bye, everybody. We'll do the
Bye, everybody. Bye.
Yeah. Okay, in meeting. Bye-bye.
Bye.